We have Ms. Ball arguing for Parks Finishing, and Mr. McAfee, you will be here for Leffler's. Thank you very much, and whenever you're ready, please proceed.
Your Honors, may it please the Court, my name is Megan Ball, and I represent Appellants Parks Finishing C7 and C8 in today's appeal. This appeal asks the Court to provide clarification on a basic inquiry into how Iowa courts interpret contracts between parties. It's appellant's position that Iowa precedent reaffirms time and again that the role of the court is to give meaning to the entire agreement within the ordinary meaning of the language used. And only when the language of the agreement is ambiguous do Iowa courts utilize secondary resources, like canons of construction, to determine the party's intended meaning. The court should reverse the district court's grant of summary judgment for 3 reasons. First, the district court relied on a canon of construction, the last preceding antecedent, without first considering the unambiguous contract language. This is reversible error. Second, the district court's interpretation renders portions of the manure easement superfluous, contrary to Iowa law. And third, even if this court finds that the application of the canon of construction was proper, the district court applied the canon incorrectly.
Second argument, how is part of this, how does this interpretation of the court make part of the language superfluous?
Yes, Your Honor. The district court's interpretation finds overall that any party is permitted to unilaterally cancel the contract by 18 months written notice. And if that is true, that at any time the contract can be canceled by one party, there's no reason for the 20-year term within the contract. The 20-year term is meaningless. It's really an 18-month by 18-month term, so long as the parties continue not to cancel that contract.
Well, why couldn't it be interpreted to say during the first 20 years, the only way you get out is by giving it the 18 months notice, whereas when we're in the extension period, you can give 18 months notice, or you could also cease operation of the hog operation. That would make both the 20-year and the extension period have meaning. So I'm not understanding why that makes the 20 years superfluous.
Can you repeat the first option that you said, the 18-month unilateral termination?
Why can't it be interpreted in a way that the 18-month termination provision applies both during the 20-year period and during the extension period? But when we're in the 20-year period, you also have in the extension period, you also have the additional way of getting out, which is ceasing the hog operation, which is not an option during the first 20.
Yes, Your Honor. I think the reason that option does not exist is by the use of unless, or continuing thereafter unless. So the addition of that phrase helps to clarify that the 18-month unilateral termination is not an option during that initial 20-year period. So under the plain language and unambiguous language of the term and termination provisions during the 20-year initial term, the only option is to proceed to sentence 3, which provides that mutual termination of the contract is permissible during that initial 20-year term. So the contract itself considers that during the initial term, the parties may agree to terminate the contract. Once that 20-year term has elapsed, then there are 3 options by which the contract can be terminated. The hog farm can cease operations, either party can provide 18 months notice, or they can mutually agree to terminate the contract. But the reason we don't even need to reach the superfluous nature of the district court's interpretation, because this argument can begin and end with the district court's reversible error by not properly analyzing whether the manure easement's language was ambiguous. This court is well aware that contract interpretation requires at least 3 steps. First, the court reviews the language of the contract. Then it determines if the plain language of the contract is ambiguous. And if so, then it can move forward with applying secondary resources, such as looking at extrinsic evidence or applying canons of construction. The court's decision.
Supreme Court pronouncement in Barnhart that the last preceding antecedent rule is really a matter of grammar. So it makes sense as a matter of grammar. So why can't that be used to give meaning to this passage in the absence of ambiguity?
I think the answer is twofold, Your Honor. First, it's that the Barnhart decision does not dictate that the last preceding antecedent must be applied anytime there are preceding antecedents in a sentence, even though it is a rule of grammar. And secondarily, the cases that stem from Barnhart indicate that the inclusion of a comma, which is really at the heart of the last preceding antecedent argument here, does not necessarily mean that the comma is necessarily evidence of contrary legislative intent. Every single precedent that is cited says that it may be evidence of legislative intent.
Karen, our Supreme Court applied this rule even though it found the language unambiguous, right? So doesn't that shoot your argument in the foot that we can't use it if the language isn't ambiguous?
Respectfully, Your Honor, I disagree. If we look closely at the language in Karen's, it discusses the last preceding antecedent rule, and then before applying it, it says, we apply, quote, a similar analysis here. It doesn't necessarily apply the last preceding antecedent, but it applies a similar analysis.
Can't we apply a similar analysis here and reach the same conclusion as if we were applying the last preceding antecedent rule?
Your Honor, the district court may have had the opportunity to do that, but the threshold issue before doing that is determining that the plain meaning of the language here was ambiguous. That'd be difficult for this district court to do when both parties repeatedly briefed and stated that the language of the document, the contracts, were unambiguous. So if the district court disagreed,
Agree that the language is not ambiguous, but they diametrically come to different conclusions. Doesn't that kind of blow out of the water the idea that this isn't ambiguous?
potentially, Your Honor, but the district court made no finding on ambiguity. So if that was the district court's conclusion, then the district court should have followed steps 1, look at the plain language of the contracts, 2, identify that there was ambiguity, and then 3, move beyond the plain language of the contracts. The district court never reached step 2 of this analysis. In fact, it relied upon overbilling for the concept that it could start with the plain meaning and then skip directly to the application of the canon of construction. But in the overbilling case itself, the court explicitly found that there was ambiguity in the documents that it was reviewing. Briefly, Your Honors, if the doctrine of the last preceding antecedent does apply, the district court applied the doctrine incorrectly. The bottom line here is that the comma is not dispositive. As I previously stated, the case law always provides that a comma may provide evidence of legislative intent, but not that the comma necessarily means that legislative intent altered the preceding antecedent analysis.
You want us to view the contract clause as if there's no comma, right?
Your Honor, it's the appellant's position that the comma doesn't change the analysis of the court here. You could remove the comma and reach the same conclusion, the same analysis. Another thing that's important.
With the comma, it would result in your position. My question is, the comma is there. Why should we ignore it?
Sure. I think under the last preceding antecedent canon, the case law, generally speaking, is addressing statutory interpretation. Now, we don't disagree that the canon does apply to contract interpretation, but there's an important distinction happening here, which is that the case law says that the presence of a comma may provide contrary legislative intent. When you are examining a statute in order to determine legislative intent, you then go back to the legislative history to determine whether that comma is supposed to mean something different than what the plain language.
Disagree with you on that, whether we can look to the legislative history and floor arguments and those types of things, right?
Yes, Your Honor, but legislative intent.
Determine a meaning and intent by the language used, right?
I agree, Your Honor, when the words itself provide a meaning, that is the proper interpretation. But in the instance that the legislative intent is not clear from the face of the statute, or in this case, the contract, you have to turn to secondary sources in order to interpret.
So is it your position that the first sentence of paragraph 3 means the same whether the comma's there or not?
It's our position that yes, the comma does not alter the meaning, in that the plain meaning, in the easily understood meaning of the provision is that there's an initial 20-year term by which the agreement will operate unless both parties mutually terminate the provision per sentence 3 of paragraph 3. And that after the 20-year term expires, there are 2 additional options by which the contract can be terminated. Either the hog farm ceases operations or one of the parties provides 18-month unilateral notice. Unless the court has additional questions for the foregoing reasons, we respectfully request the court to reverse and remand for rulings consistent.
You'll have more time on rebuttal. Mr. McAfee?
Pardon me, may it please the court, counsel. I'm Eldon McAfee. I'm here on behalf of the plaintiff in this case, the appellee here, and I guess where I will start is I'm a little disappointed the gallery's not full. We're here talking about manure and a comma. And I'm not making light of this situation. It's an important case, but in the overall scheme of things, maybe not some look at it that way. I guess as I've looked at this case, I've looked at it as, I work in this area, as did the drafter of this agreement, and clients never come in and say, give me a nice long agreement. And I don't mean to be a smart aleck here, but clients often say, keep it short, keep it simple. This paragraph, this clause is short, that's for sure. But when shortness, what happens is there's a lot packed into this one sentence that we're all talking about today. There's a second sentence about mutual termination, but I guess I've always told clients you can always mutually agree later on. So is that sentence really necessary? But that first sentence has a lot in it. And to say that, when you first look at it and you just read through it, I have to admit, it kind of all flows together. That's why it's important to have a comma there. And that comma had to be put there for a reason. And we agree, as the appellees, that the district court got it correct, using the doctrine of last preceding antecedent, more importantly, an exception to the doctrine of last preceding antecedent, and that there's a comma there. I think what really strikes me here is, I often look at a case and think, okay, if I'm going to criticize what's there and say it isn't written the way the appellants say it should be written or interpreted, I should say interpreted, I have to look at it and say, well, how should it have been done? Well, the comma could have been moved around, for one thing, or taken out. Then a whole different situation. But I think, and this is not what we're looking at here today, but I think problems with a comma and these doctrines is why our legislature, and this is not a legislative issue, so don't get me wrong, has went to specific drafting, at least in my experience, where you don't rely on a comma or an and or an or. You have it laid out with all of the following, none of the following, both of the following. And again, I'm just saying...
in any of these types of disputes, the thing could have always been drafted in a different way to clear up what has now developed as a dispute, right? If you would have known the dispute was coming, you would have drafted differently, right? So here you could have, where the comma is, put a period and then said, during the initial 20-year term or any term thereafter, either party can terminate by giving the other party at least 18 months notice, right? You could have done that. And presumably would have cleared up any uncertainty as to what it means. But is it your position that the comma basically does that same lifting?
Yes, Your Honor.
What about this business about, do you think this language is ambiguous? I mean, and Justice Mansfield has said, look, just because creative lawyers can pitch two different meanings of the same clause doesn't make it ambiguous, right? It can still be unambiguous even though the parties are squabbling over what it means. So I'm not trying to trap you with this question. I'm just curious in my head trying to sort out, is this thing ambiguous or is it not? And does it really matter whether it's ambiguous or not?
I think you've hit on all the points, and I'm not just saying that because you asked the question. I looked at it the same way. I think we all did. First of all, is it ambiguous? We're here arguing about it. So does that mean it's ambiguous? Some might say yes. I'd like to point to the Cairns case, if I'm pronouncing that correctly, cited in our brief, but not on this issue necessarily. At page 824, the court said, ambiguity exists if, after the application of pertinent rules of interpretation to the face of the instrument, genuine uncertainty results. That's after we apply what we're talking about here, and this is the doctrine of last preceding antecedent and the exceptions. So I think we passed the test of not being ambiguous there. Secondly, the court also said, and this goes back to what I was talking about, how it could have been written, ambiguity is not present merely because the provision could have been worded more clearly or precisely. So the court recognized we can always say, as I think you've indicated, Your Honor, that we're here, yeah, we all look back and say, well, here's what could have been done, but that's not the definition of ambiguity. We have to take it at the time it was written and whether it can be interpreted using the principles of statutory construction.
Opposing counsel's argument that and I'm not to put words in her mouth, but as I interpret her argument, which is the comma doesn't matter, you get to the same result with or without the comma. So the comma doesn't really mean anything, doesn't add anything to this sentence. What's your thought on that?
I strongly disagree. The comma is the key to this case, the way this sentence was written, and that's why we use this canon of or doctrine. It has to have meaning, otherwise it shouldn't have been put there. And all this court can do right now, as the trial court did, is look at it trying to determine the party's intent based on the words on paper, and the comma is critical to how it has to be interpreted.
Their opposing side's interpretation would be correct if the comma wasn't there?
Yes.
Okay.
Does your interpretation conflict with the last paragraph of that paragraph? Or last sentence of that paragraph?
That would be the mutual termination? No, I do not believe it does, Judge. I believe that, again, I think that's always there. Two parties can always determine, hey, we need to change something, we need to terminate whatever, and this just put it out in writing. And sometimes that's helpful to clients to see something like that. But I do not believe this conflicts. I guess I will end unless you have, well, one other point, and I don't know that I need to revisit it, the argument that that our interpretation makes the initial term superfluous, and I agree with the court's analysis there, that, and it's in our brief, page 17, that this qualifier put in for the extended term that if the operation is still there, does not exist in the initial term. So the
difference between the 20-year term and the extended term is during the first 20-year term, it's your position that even if the hog operation ceases to operate, they're still on the hook for their obligations under the agreement unless they give the 18 months notice or we mutually agree.
Correct. And I believe, as we state in our brief, it would subject the hog farm that is terminating to at least 18 months worth of damages for not giving the 18 months notice. But yes, I believe that is exactly the difference between the two terms. And
we're in the extension period, then if the hog operation ceases, it's an immediate out. Okay. Okay.
Here's what I had to do. I heard someone in a previous argument today mention a diagram or whatever. I had to take this and make a table and put in one column, if the hog farm is in operation. And I would agree, if it stays in operation, there really is no difference in the two terms, before and after. If it goes out of operation, that's when the difference comes between the two terms, and that's why our interpretation is not superfluous.
You didn't share it with us in your brief?
Diagram.
I don't know that I made that kind of, but I just, yeah, I didn't share it with you, but it is explained. Ms. Cassidy, my associate, did a very good job of explaining it on page 17. The table was for somebody like me to understand it. Thank you.
Any rebuttal?
Court. I want to begin with the simple premise that this court does not actually need to reach the question of whether ambiguity exists in this agreement. The question really is whether the district court needed to reach that question. And I want to look specifically at the Supreme Court's decision in Beverage versus Alcoa, Inc. It's a 2022 decision. And quoting directly, the Supreme Court says, "Our first step is determining whether the meaning of the provision is ambiguous. If it is not, we go no further and apply the unambiguous meaning of the language used in the provision." It then continues on to say that if it is ambiguous, then you turn to applying canons of construction or other secondary resources. And secondly, in terms of the question of whether or not leaving the hog operations in the 18 months have any impact that differs between the initial 20-year term and afterwards, we would again point the court's direction to the specific language and shall continue thereafter in the second phrase of the first sentence of paragraph 3. All of the language after this phrase is the last preceding antecedent that is applicable to the continuation of the contract. So both the 18 months and the leaving of the hog operations are applicable after that initial 20-year term. It is not as...
Understanding that it doesn't have to be applied, but generally a comma changes that application, doesn't it, under that rule?
The comma under that rule would state that the last preceding antecedent only applies to the immediately preceding antecedent. What my co-counsel here is suggesting is that because of the exception to the last preceding antecedent rule, that 18 months unilateral termination should apply to the entire preceding antecedents, not the last preceding antecedent. So the debate over the comma is whether the 18 months unilateral termination applies to all preceding antecedents or merely the last preceding antecedent. It would be our position that it applies to the last preceding antecedent, which under the rules of grammar would be the continuation of that contract and shall continue thereafter once that initial 20-year term has been completed. All right. Unless the court has additional questions, we ask that the court reverse the district court's decision.
Today, even if we didn't have a Venn diagram, we think we get your point. So, but please consider 250441 submitted, and my colleagues and I, we appreciate the great arguments in the briefing, and we also will get you a decision as soon as we can. Thank you.